I started life in the intellectual property field as a patent examiner at the UK IPO in Newport. And the one thing I discovered there, fresh out of university and 22 years ago, is that as a patent examiner, we were given very little concept of the commercial value and importance of intellectual property in the real world. And I guess that's in the name of impartiality, and it's the right thing that a patent examiner gives no thought to the potential commercial value of, for example, a patent. But I very quickly decided that the role of impartial civil servant was not for me, and decided that I would rather be on the front line, and jumped ship in 1994 to become a patent attorney. Now, one of the things that I've discovered, or I discovered very early, I guess, as a patent attorney, a young patent attorney, however many years ago that was, I'm not going to repeat it, is that there's a lot more to the intellectual property world than I've had a great idea, I'm going to protect it, put it on the market, and I'm going to sit back and watch the money roll in. And, you know, as many of you in the room know, if only it was that simple. So what I want to talk to you about today, after I've done the usual spiel about what is intellectual property and what can it do for you, is I want to talk a little bit about IP issues that are not talked about as much as they're not talked about much in this type of forum. So I'm going to kind of go off-piste a little bit and talk about the less talked about IP issues that are particularly relevant to the design, prototyping and launching process. And I'm going to touch exceptionally briefly on the sources of funding available to you. There is a really good reason for that, and that is that those sources are very fluid. They come and go. European money comes in, it's administered, and then that source of funding disappears, and you have to go searching for where the next source of funding is. So all I'm really going to do is point you in the direction of what I discovered during brief research for this talk, where the money is at the moment, and it's certainly a good starting point for those of you looking for funding, but it will be a very brief part of this. Okay. Oh, that's exciting. I didn't do that. Amy did that. Okay. Intellectual property then. Commercial asset. This is the usual spiel. I have a suspicion that 90% of you in this room have heard this before. It's a commercial asset like a building or a piece of machinery that can be licensed, bought and sold, and is intended to give its owner the right to prevent third parties from copying their innovative efforts. And I use the term innovative efforts on purpose, and I'll show you why in a minute. But I just want to touch back on a couple of words I picked up on in Phil's talk, where he talked about IP infringement, and very kindly said I was going to talk about that, and copycat products. Now, what I wanted to highlight was that intellectual property enables you to prevent third parties from copying you. But having a patent or a registered design does not necessarily stop you from infringing other people's intellectual property. So it does not give you the right to do what you want. It gives you the right to prevent third parties from copying you. So that's the difference, and that's why Phil had them as two separate bits on his talk, I assume. IP infringement and copycat products are two separate things, and it's important to highlight that. So, as Phil has already explained, there is quite a long process from concept to market. And the rule of thumb is, if it's required investment of time and money to develop, it probably attracts some form of intellectual property right. Now, so you've started with your concept, and obviously you think that that's great and it's innovative, and it probably is, but there may be quite a lot of other intellectual property developed during the development of the product, so from concept to market. Things like, and I will talk about this a bit more in a bit, but things like packaging, branding, even certain technical problems that might have needed to be overcome between Mark 1 prototype and Mark 5 prototype when you're testing the concept. Anything that's required investment of time and money may have intellectual property and needs to be thought about. Okay, so there you go. It needs to be considered at all stages. All right? Okay, so what is IP? There are 3 general headings under which IP falls. The registered rights, that's patents, registered designs, and trademarks. I suspect that some of you, at least in this room, will have been through, at the very least, the patenting process and know that it can be quite a complex, legal and costly process. It usually involves the payment of fees, at the very, very least. But tends to provide slightly stronger protection, or much stronger protection actually, than the unregistered rights there, copyright, unregistered design right, which usually come into force automatically when a work or a design has been generated and recorded, drawn, or whatever. But the one limitation of unregistered design rights is that you, in order to prove somebody's infringed your IP or your intellectual property rights, you have to prove that they copied you, actually copied you, rather than came up with something independently, ended up with something very similar independently. And I have a story from a few years back where this was, it was highlighted to such an extent, and it was devastating for a client. A client came in to us, and they had a business designing and manufacturing fishing accessories. Little Welsh company, but they were actually doing very well. Apparently that's a huge market, fishing accessories. And they had designed a product, and they had put it on the market, and they were making quite a large profit from it. And then discovered that a Chinese company was manufacturing them in bulk and was undercutting them in the market, and seriously affected their profit margin to the extent that they were on the verge of going out of business. It was at that point that they came to us, and they had no registered intellectual property rights at all for this design. And by then, of course, because it had been publicly disclosed, most of you will know that when something's been publicly disclosed, it certainly can't be patented, and there's only a very short space of time within which a registered design can be filed. Both of those deadlines, all of that had passed, it had been disclosed, and they had no registered rights. So it was decided that they would take this Chinese company to court on the basis of unregistered design right, which effectively protects 2- and 3-dimensional features of the shape of, in this case, a fishing accessory. And off they went to court, and as I said, they had to prove that this Chinese company had actually copied them. Now, from their perspective, although there were a couple of very, very minor differences, this product was basically the same product, it looked the same, and in fact, somebody just looking at the two on the shelf could be very much, could be forgiven for thinking they were in fact the same product from the same place. And so everybody went to court feeling actually quite confident. Now, this is some years ago. This is maybe 12, almost 15 years ago, maybe, when internet selling, although it existed, it wasn't particularly prevalent. And the judge found against our client because the company was, in fact, in China. There was no provable direct link between the Chinese company or any employee in it and our little Welsh company, and had decided that actually they may not have copied, that hadn't been proved. China's a long way away. They hadn't proved a link between the two. As I say, internet selling and the fact that they may have seen it on the internet or anywhere else for that matter and copied it couldn't be proved, and our client lost and in fact went out of business, and it was very upsetting both for them and actually for us. But it's a really good example of how registering your intellectual property rights, had they had a registered design or in fact a patent for this product, all they'd have had to do was show that they were making the same thing as them. All they'd have had to have proved was that they were doing it, not why they were doing it. They could have come up with it independently or copied it. Either way, they would have been guilty of infringement. And that's the big difference between registered and unregistered intellectual property rights. And then I've put confidential information in there. It's not strictly an intellectual property right, but it has many of the same characteristics. It can be licensed, bought and sold in the same way as registered and unregistered intellectual property rights, and that's why it's there. The one thing that is important about confidential information is maintaining that confidentiality. Once confidentiality is lost, so is its value to your business. So it's very important to be careful about that. Okay, very briefly then. Patents protect solutions to problems or gaps in the market and apply generally to new products and processes. They apply to other things as well, but I think just for the people in the room, that probably covers it. When we say solutions to problems, we don't necessarily mean groundbreaking, earth-shattering problems that are causing major worldwide difficulties. The level of innovation varies from market to market, but basically, I heard one of our partners say this the other day, and it's lovely, the devil is in the detail. If you have solved a problem, if you've identified a problem in the market and you have solved it, then it is highly likely that the detail of how that problem's been solved is protectable by a patent, and it is always worth talking to us, and there's the first shameless plug for the firm. It is always worth talking to us about whether or not something's patentable. Okay. Registered designs protect 2- and 3-dimensional shape of a product, and they may also protect surface decoration. Now, I'm sure Phil will tell you that an enormous amount of effort goes into, in many cases anyway, the shape, look, and feel of a product once the concept has been realized into perhaps prototype Mark II, Mark III. When the concept's been proved, a lot of effort goes into how that product looks and feels, and it's there that registered designs may very well come into play. What it does is it protects somebody from making something that looks the same. So the underlying concept is irrelevant for registered designs. The underlying concept of a product might be quite different to yours, but if it looks the same, your registered design will protect you from infringement. There we are. Oh, that's clever. I didn't do that either. A lot of time and money spent on the appearance of a product needs to be protected against copying. Okay. Trademarks. I'm going to touch on this again in a minute, but for the second, and I know that many of you will be aware of this, it protects brand names, logos. It's intended as a badge of origin. It's intended for you to be able to build up a business so that when people see that brand name or logo, they will know that it originates from your company. There you go. I'll talk about them again in a minute as well. Okay, very briefly then, copyright protects written works as well as music and film, and more importantly, software code and databases. Okay, unregistered design right, very similar to registered design, except for the in what it protects, but it's much, much weaker protection. Okay, and although it's not an intellectual property right as such, know-how, trade secrets and confidential data can be licensed, bought and sold just like intellectual property rights. Okay, so you have an idea and you don't know, and you need to talk to somebody about it. You may need funding, you may need somebody's help to develop it. What do you do? Now, in terms of registered intellectual property protection, it's quite important, especially patents, to keep your idea a secret until a patent application is filed. You have two choices at this point, because you need to talk to somebody. You have two choices. Do you file an initial patent application, or do you use NDA, non-disclosure agreements, or confidentiality agreements? And for the avoidance of doubt, they are the one and the same thing. I believe NDA is an American term, but they are one and the same thing. So do you use one or the other? What are the benefits and what are the pitfalls? Well, filing an interim patent application, filing an initial patent application has the benefit of planting your flag. I say that in inverted commas. It gives you an initial date. It gives you the earliest date possible that says, this is my invention, this is the scope of my invention. It does have that benefit. The downside of it, apart from the cost, which we'll brush over a little bit, because that varies from case to case, one of the bigger downfalls is that it sets a 12-month clock running. Within 12 months, what we need to be doing or need to have done is have decided what our final scope of protection is and refiled the application claiming our original date back. So there are two, I guess that there is one major benefit of filing an initial patent application, and that is to plant your flag at an early date and give you some protection when you're disclosing to third parties, even if that's under confidentiality agreements. But the big downside, and in some cases will be a big enough downside to prevent it, at least for a little while, or delay it, is that it sets this 12-month clock running. Benefits of NDA confidentiality agreements, generally free. The downside is actually that it's a little harder to, in fact it's significantly harder to obtain the recourse if things go wrong. So if somebody breaks a confidentiality agreement, that's contract law, and really the only place to get any recourse for that is via a court action. So whilst it provides protection in theory, in practice, in many cases, actually getting recompense for somebody disclosing your confidential information can be prohibitive. Okay. So we're going to move on then to patent searching, and again I come back to what Phil was saying here. When we talk about patent searching, there's two types. There's novelty searching, which is my idea novel? Is there a novel feature of it that would make the idea potentially patentable? And then there's the infringement and freedom to operate search. Will the sale of my product infringe someone else's rights? The two very different things. Infringement searching, for one, is much broader than novelty searching. Okay, and it's also in general much more expensive. However, it is also territory specific. So if you're only going to be selling in the UK, you would only be doing infringement searching in the UK, whereas novelty searching needs to be worldwide. Okay. But what I really wanted to talk about today in terms of patent searching is using patent searching as a design tool. The patent system, or the intellectual property system, has been in place for many hundreds and hundreds of years in various formats, and it's usually one of the first statutes to be put in place in a developing country. It's a deal, basically, between you and the government in return for adding to the body of knowledge of the world, in return for disclosing scientific, technical information. You will be granted a monopoly of a limited time within which to exploit that knowledge, that invention. And so the body of knowledge of the world, and in particular that country, I guess, is constantly increased. That's the deal. So patents and patent applications which are published in order to improve, increase the body of knowledge available, has become a huge research tool, almost, and can be used to avoid the reinvention of the wheel, so to speak. What I mean by that is that not necessarily your principal concept, but when we're going from Mark 1 prototype to Mark 2, Mark 3 and refining, technical problems come up which may require solutions. And before we spend thousands and thousands of pounds trying to come up with that solution ourselves, it may be worth doing a patent search to see if we can come up with, find somebody who's already come up with this technical problem and found a suitable solution. Okay? Now, I think some of you may be familiar with Espasnet and Google Patents for novelty searching, and the same resources can be used for this purpose. This example, you have to forgive me for this, but you've come up with a design for a road barrier. And the idea is, the real novelty lies in the fact that this barrier comes in modular form and can be easily fitted together and disassembled in comparison, for example, to the Rhino barriers at the Severn Bridge, which actually require big fat metal bolts, and once they're there are effectively permanent structures. So this is what you want to come up with. I do realise it's been done before. That's really the idea, because one doesn't want to be inadvertently giving away people's secrets. So this is an old problem and an old invention, and please rest assured that I'm not giving away one of my clients' deepest, darkest secrets. So the real, you've gone to somebody, either gone to somebody like Phil, or you're trying to do your initial, which I don't recommend by the way, but you're trying to do the initial prototyping yourself. The novelty lies in the fact that this thing is modular, and you can put it together and disassemble it really quickly. And I guess most of the innovation is going to lie in the material and the structure of these modular barrier pieces, because they're going to have to be hard enough and absorb enough shock in order to actually work to stop a car or a lorry if they happen to bang into them. But what we really want, what we don't know yet is how these panels are going to be connected together. We want to be able to connect them together easily and disassemble them, but that connection needs to stay in place, especially when it's hit. And we want to be able to connect corners if we have to as well. So, during the prototyping process, you need to work out the best way of creating these joins. What do? Well, I would go to a SPASnet. And with any luck, this hyperlink will actually work for me. Oh, there it is. Okay, so we open a SPASnet at the EPO, and what will come up is a smart search bar, and I'm going to put in modular barrier and joint. Okay, it's keyword searching. So what we're looking for is a joint for a modular barrier, and that I think's come up with 20 results. And then we can look down and have a look and see whether, for example, panel wall systems, well, they need to be strong. Let's have a look at what the joint shows, what joints they've used for that. Okay, so I won't dwell on that too much, but it is worth bearing in mind. Okay, the other type of searching. When you come up with a great idea, or when someone comes up with a great idea, what inevitably follows exceptionally quickly is a really great brand name. Okay, it's the nature of people trying to commercialize new concepts and innovation. You think of a really great idea, and almost immediately a really good brand name will come to you. Okay, now the best thing to do, and this must happen before you commit to it, rather than before launch, before you start putting this brand name on your paperwork, on your packaging, it is essential that you do some trademark searching. I would recommend, another shameless plug, sorry, but I would recommend that you use a trademark attorney for this, because they will not only perform the search, but they'll also advise regarding the inherent registrability of your brand name. There are things that can and can't be registered. There are various things to be considered, and this will save you a lot of time and money before the launching process if you do your trademark searching properly and then register your own trademark before you commit. Okay, now I'm going to touch on packaging. This isn't mentioned very much. We've gone through Mark 1, Mark 2, Mark 3, Mark 7 prototype, and we finally got a product we want to launch. Packaging is often one of the last things that comes under consideration, But there are intellectual property issues that need to be considered, and they are quite often overlooked. And I'm not for one second saying they're overlooked when you use D2M, but they are, when you don't use D2M, they may very well be overlooked. And it can be very costly. Okay? Now, quite often packaging is commissioned by another company. Okay, so the first thing we need to determine is who owns the intellectual property rights in your packaging design. If you commissioned another company and you did not have an agreement to the contrary in place with them, they will almost certainly own the intellectual property rights. Now that's fine if you've just asked them to put together a brown cardboard box with a label on it. But quite often, packaging in and of itself becomes quite distinctive in relation to your product. And what you don't want to do is leave yourself open to that commissioned company being able to use the same or similar design for other clients, okay? Because packaging in itself can be a badge of origin, and I'll show you why in a minute. Okay, so if you commission another company to design your packaging, you must have an agreement in place that you will own the intellectual property rights in what's been designed for you. Very important part of the law. Okay? And as I said, because if the packaging is particularly distinctive, you may not want that design company to be able to reuse. Obviously, if you are just asking them to put together a brown cardboard box with a label on it, this becomes less of an issue. So if you own the IP rights to the design of your packaging, are there any technical advantages to this packaging? I've done, over the years, quite a few patents for packaging companies, actually, where technical advantages might include, I don't know if you've seen them, but the point-of-sale chocolate bar boxes that actually, the packaging that they come in fold in various different ways, and then they can actually be put at the point of sale without removing the chocolate bars from the boxes. Now, about 20 years ago, or whenever it was, that was actually quite innovative, and there are various patents around for that. Also, ease of assembly. There are patents in place for these kind of flat pack boxes that with one flick of the wrist, they become boxes. There are patents out there for that as well. So have a think about it, because you may want to prevent others from copying. You may also want to consider a registered design, because the look of your packaging may very well be important to your commercialization of your product. And in some cases, trademark protection might be appropriate for packaging design as well. And as I say, I will touch on that right at the end. But the one advantage of trademark protection over registered designs is that trademarks can last forever, and registered designs last for 25 years. Okay. In any event, even if you've got a brown box and a label, mark your intellectual property rights on your packaging. Okay? Use numbers for registered designs and patent applications, not just patent pending. Trademarks, this is so important. Trademarks clearly marked with a subscript TM. If you're using a brand name as a trademark, if you're using a name as a brand name or trademark, use TM to show that you're using it as a trademark. If it's unregistered, you can only use R in the circle. If it's actually registered, it's illegal to use R otherwise. So please be careful about that. So don't overlook the potential importance of packaging, and this is what I wanted to talk about. Finally, the Coca-Cola bottle. Okay, the designer was told we want a bottle which a person could recognize even if they felt it in the dark, and so shaped that even if broken, a person could tell at a glance what it was. That was his design brief. I'm guessing it gave him a few sleepless nights, actually. But anyway, this is what the result was. It's one of the most widely recognized packages on the planet, and is protected in many territories by a registered trademark. Now, that's beneficial because a registered trademark can last forever, whereas registered designs have a limited time frame. So this is really just an illustration of how important packaging can be to a business, both in the short and in the long term. And in fact, Phil touched on this with the hairbrush, where actually potentially the packaging and the branding was more important than the product itself, or indeed whether or not it did what it said it was going to do. Okay, very briefly then, and this is just one slide. When I researched this for this talk, sources of funding for SMEs and individuals, innovation networks in West Midlands, local investment funds in Wales, and Millennium Awards and Technology Strategy Board. They are nationwide. As far as I can understand it, they have tranches of money that comes in, gets administered, and then they'll have a period where there's no money and then more money comes in. That's how I understand that these work, but they are worth checking out. Nowadays, a lot of the local governments have got sections, have actually got a local business section, which can also help with this type of thing. But I actually have a client that's dealt with innovation networks in the West Midlands and has found them exceptionally helpful. There are others. It is worth Googling, it is worth checking out, and check it out with your local government business department. Oops. And that looks like it's the end of my talk. Thank you.